So welcome everyone to the last match 6 out of 6 of the CyberT20 series. So today's session, as mentioned yesterday, it was something related to cyber laws. It was planned. We had a expert, a senior lawyer, but he was stuck with some important cases in Supreme Court for his clients. So I'm coming out of the box as a substitute just to let you know what is meant for this cyber laws session, the last day. We have got some inputs from the speaker. And also we are just going to let you know, walk you through the last 3 years. What was the expertise? We are just working with Kriyavan with respect to digital forensic and investigations. So without any further delay, we'll just quickly start with the session. So everyone knows CyberT20 is all about 20 plus 20 plus 20. And we had quite a good number of expertise speakers, match 1, match 2, match 3, match 4, and a couple of cyber bites. And we had match 5 yesterday. We had Charles Philip from banking sector clearly explaining about specifically on threat intelligence and on do's and don'ts. Everyone knows about these do's and don'ts of T20s. We'll quickly walk through our actual things. Okay. So today's discussion is about cyber laws. Fine. So before we start with something on cyber laws, I'll just give you some fancy numbers, right? So if I ask you to give me some fancy numbers, can someone type a fancy number in a chat box? We'll make this session a bit of interactive. Can someone type fancy numbers in the chat box? We'll make it interactive. I'm typing something from my intent. I believe 777 is a fancy number. Fine. So I've typed in the chat box. Yeah, 007. Yeah, James Bond. Fine. Same way, I'll just give you a fancy number, 420. Not much of fancy in terms of number sequence. But 420 is most common fancy in India. If someone commits a crime, we call them, hey, you are a 420. What does that mean? We say to them saying that, hey, you have committed a fraud and I believe you have to be prosecuted in the court of law under section 420. If someone is hearing this for the first time, Indian Penal Code, IPC laws, 420 is a section in which a case can be filed against someone when they commit a fraud or an offense or something unethical, unlawful, right? Any on the grounds. We call them a single word fraud, right? Someone commits a fraud, we can file a case against them in 420, right? But let's jump on to our core area, something on digital evidences, or else there is an act in India called IT Act. Before starting this, right, we are not cyber lawyers. We have a pool of experts who guide us on this, right? So whatever we are discussing today, okay. Whatever we are going to discuss today, we start with the disclaimer saying that we just talk about the technical part of the cyber laws, right? And then we have a pool of experts who's guiding us on the court proceedings, right? But we have a team who's going to quote as an expert, who's going to be there and saying that, sir, this was the photo that was available in the mobile. This was the email that was deleted, right? We call it as an expert witness in the court of law. With this disclaimer, we'll get on to the main thing, right? From paper to digital justice, right? So you say, like, I remember starting my career 20 years ago, 2005, talking about cybersecurity, talking about the so-called hacking. Those days, hacking is only hacking a computer, a traditional computer in an office or else an institution. Not even a single individuals might have much of computers, right? But nowadays, you see something like a crime or a cyber crime or a hacking is something entirely different. Mobiles are hacked, social media accounts are hacked. Even now, someone is getting into virtual reality and some of those things. Those identities are getting hacked or compromised, right? So when we started learning a decade ago, right, there were no legal frameworks for cyber laws. And I remember 10 years ago doing some certifications online on cyber laws from a university from Pune. Okay, so we'll start with this, what you see here on the screen. In a nutshell, in India, just like we talk about Indian Penal Code, IPC Acts, 420 likewise. So if you want to file a case against someone, if you want to prosecute someone in the court of law, they have done a committed offense that is related to a digital evidence, an audio, a video, a WhatsApp message, a photo, or anything that is in bits and bytes, zeros and ones as a digital evidence. This law comes into place that is called IT Act. IT Act that was amended in 2000, sorry, initiated in 2000. I have taken this from varying source, so I have just quoted the citation also there in the thing. So 2000, that is something called IT Act. 2008, the term for computer, the term for hacking changed. It was amended. Typically, some changes was made. It was made as IT Act 2008. Recently, maybe a couple of years ago in India, we had a major change in the cyber laws. The IT Act was refurbished into BNS, BNSS, BSA, right, in different names, right? And finally, it was implemented last year in the Code of Laws. So we are going to quickly walk you through what are these acts in the first part, maybe the first 20 minutes. And the next part, we'll discuss about how we just give evidences on this, right? So everyone will come to know how to produce a WhatsApp message, how to produce an email in the court, how to produce a photo that was taken from a mobile in the court, right? That's the agenda for today's session. Okay, we'll quickly walk on through this. Yeah. So the IT Act of 2000, it's called Information Technology Act in India. That was the foundation of digital India. Digital India in the sense with respect to laws, right? So you can prove anything that is in pen and papers, right? Typically in bytes and bytes in the code of law, right? Older days, there was only written documents that have been proven in code of law, right? So based off traditional laws of e-commerce, based upon UK, US regulations, unilateral modern laws of 1996, in Indian government, we passed something called IT Act in 2000, right? It came into force on October 17, 2000. That is called Information Technology Act in India. Okay, what is the objective of IT Act in India? Legal recognitions to electronic transaction. Anything you transfer nowadays, we say, right? So you might have heard, you hear a call, sir, say the 16-digit number from your card. Someone share your OTP, they steal the money. This is not now. It's happening for the past 10, 15 years, right? So this act says like, okay, something that can be proven in the court with electronic transactions, right? Anything you just transfer, we call it as transfer over the wire. Instead of counting the money and giving, you transfer it over the internet, right? Then digital signatures. I hope we have heard of digital signatures from past speakers, right? Digital signatures is a validation signature, right? Even if you want to sign a contract, nowadays you want to upload anything into government website, you need to digitally sign from your individual or your company ID. Framework for e-governance. Nowadays we are so comfortable with GAFAM, Google, Amazon, Facebook, Apple, and Microsoft, the ecosystem which we are in, right? In older days, there were like something called eBay and older things. This is the framework for e-governance. If you are going to do some transactions online using computers, there should be a framework, right? And finally, it's going to cover the cyber crimes, prevention and penalties, 94 sections, 13 chapters, and 4 schedules summarizing this, right? So they have digital signatures, how to deal with frauds related to digital signatures, electronic record, right? So a record that is in electronic form, audio, video, photo, text message, emails, how to prove them. Cyber offenses, we'll quickly walk you through what all the different cyber offenses. Just we'll cover the 66 of IT Act, right? Then the following is adjudication mechanism, right? Typically, who can do it? Maybe when you file a case, maybe there will be something like a police involved. There are some other government regulatory bodies involved, right? It can be a civil case. It can be a criminal case. A cybercrime comes in a hybrid. It covers, depending upon the nature of the severity of the crime, it can come on any of the civil or criminal conduct. So that was IT Act 2000. The first on the benchmark law in India for cyber crimes. Fine. Then it was amended in 2008. Why? In 2000, computer means you see a big box, maybe a cabinet, you have a big monitor. That was a computer. In 2008, something changed. After internet being familiarized, laptops came in, mobile devices came in. Not only a computer, laptop, mobile device, any device which is capable of storing, retrieving, transmitting data comes into this. So IT Act 2000 was amended. Amended means some changes was made, some updates, right? And it was made as IT Act amendment in 2008. It was a game changer. Why? Because you see, there was a clear picture till 2008. There was no picture of social medias. Nowadays, everyone is comfortable with. There may be some Snapchat kids, maybe 2K kids. There may be some Instagram, 90s, right? There may be some Facebook below 90, that is 1990, right? And you remember those who are age old, like we had something called Orkut in 2000, 2005, right? So those 10 crimes happened using those social medias. They cannot be addressed in the court of law. Easily, someone who is convicted can escape. So in 2008, there was an amendment made, call it as social media platforms, how to regulate a crime happening in social media platform. Identity theft, right? Creating a fake account, hacking and stealing someone's account, right? All these things. Cyber terrorism, right? Nowadays and even those days, terrorists, those who want to promote their modus operandi, those who want to promote their ideas, they started promoting using social medias. Nowadays, you see, right? You get, if you want to make something viral, you put a meme, you put a WhatsApp message, right? Data privacy concerns. Who is having my data? You are a company, you are an organization, you are an individual. When you go and search on internet, how many websites your Gmail IDs are there? How many places your passwords are there, right? And all these things made the amendment of 2000 to 2008. That is called IT Act 2008 Amendment. It came into effect on October 27, 2009 in the Court of Law in India. And they have quite a good number of sections, many sections, right? So we will just let you know whatever the sections we are dealing with. Dealing in the sense we are providing digital evidences. 66 is a major section of the older 2008 IT Act. 66 has A, B, C, D, E, F, right? We'll quickly walk you through this. What is there in this? 66 is a common act for hacking or computer related offenses. Right? 2000, there's a keyword called computer hacking. Then it was renamed as computer related offenses. As I said, any computing device, it can be a mobile, it can be a laptop, it can be a tablet. Instead of calling it as a computer, they made it as a computing device, broad scale, right? So what does it mean? Dishonestly or fraudulently getting something in digital form. We can steal it, we can reproduce it, we can sell it, we can even have it, right? Downloading and keeping pirated movies, right? So 66A is the first act called sending offensive or false messages. Nowadays, it's most common, right? So sending an offensive message in WhatsApp, sending something on Instagram, right? So that was the act. You see, for every act at the bottom, you'll see a punishment and imprisonment up to 3 years. And it's go hand in hand with Indian Penal Code also. Someone can file a case against you in 66 and they can file in 379 and 406 of IPC also. Fine. So 66A is typically sending a offensive or false messages. But you see, exactly 10 years ago in 2015, yeah, many individuals or authorities started misusing this, right? You see, this was a judgment given by Supreme Court, I hope in 24th March 2015. Remember exactly 10 years ago. So this 66A of IT Act was removed or it was mentioned as unconstitutional. Why? Because, see, there were 3 incidents as you see here on the screen, top right corner, November 2012, 2 girls from Mumbai was arrested for putting a post in Facebook saying that a national, some leader in the Bombay was dead. Because of that, the shops was closed and everything was done. These 2 girls have put a message why they are doing like this, but they were arrested under 66A. Then April 2012, a chemistry professor from West Bengal was arrested for putting some social media cartoons that was against their state ministers or something. Then October 2012, a businessman from Pondicherry was arrested for putting something against some ministers, right? And it was like completely against, right? You might have studied in schools, right? Civics, right? History. Same way you might have studied about something rules, right? What all the rules and regulations. And we have rights and duties. Being a citizen of India, I have a duty to do something. I have a right. Right to freedom of speech, freedom of expression. This law completely came against the right of freedom of speech and expression. Right. So in 2015, some amendments was made and this was put in as unconstitutional. Even thereafter, there were some cases, something has been filed on this section, but on this date, it was mentioned, this 66A was diluted, saying that, hey, no one can use this for so and so purpose. Now we'll move on to the main section, 66B, dishonestly receiving a stolen computer. Computer means not only a computer, it can be a mobile, it can be a mobile code, it can be a SIM card, it can be a software program, it can be a pirated software, right? Dishonestly receiving a stolen computer resource or a communication device is comes under 66B of IT Act. Then 66D, identity theft, right? Fraudulently and dishonestly using someone else's electronic signature, password, identities, just like using a hacked account or compromising someone's account without their knowledge, getting their OTP and using, comes under 66C. That is identity theft. What is your identity? You have a bike key, your bike key is your identity to use the bike. Same way, you have a username, you have an email, you have a password, you have a login, you have a credit card, right? Sir, and the card mail like a 16-digit number solungo, right? So whatever you have in your credit card, the identity, the number, the date, the expiry, this CVS code, right? Everything is your identity. So someone has stolen that, we want to prosecute them in court of law, this section appears. 66D is maybe extended version of 66C, personation. Cheating by someone else. Someone calls you and say, hey, I'm your college principal. I'm in an emergency. Send me some money. We received a call last week saying that someone have impersonated a college principal who was on vacation. They have sent a message to all their faculties in WhatsApp and Telegram exclusively. I'm in an emergency. I'm in, say, Maldives. Send me money to this account. Many people have sent money because what has happened? Someone have impersonated. That is personation. Speaking as if you are the other person over a call or a mail or a message or even an SMS matters. 66E is personal privacy, right? Peeping into someone else's privacy, right? That's called voyeurism in dictionary terms, right? Most common example, the most abusive example is here is hidden cameras, right? You might have heard of having hidden cameras in dressing rooms, hotels, right? Some places. That's what you see. If you noticed, or next time when you move around, you notice in some places there may be a board. Hey, you are under CCTV surveillance. What is the need of that? Because that's a part of the act. If you have been monitored in a common place, right? You should be notified saying that you have been monitored. So only they put a note saying that you are under CCTV surveillance, right? 66C says violation of personal privacy. That's called voyeurism, like hidden cameras in rooms, hotels, etc. 66F, I give you a couple of laws, cyber laws. This is on IT Act 2008. Now in the new laws, the section numbers might be changed, but keep in mind, one is cyber terrorism, second one is child pornography. I repeat, one is cyber terrorism, the other one is child pornography. If you, your mobile, your laptop, your email, or any of your belonging or your company belongings have something related to cyber terrorism, have something related to child pornography, without any prosecution, it can be taken into custody, right? So, right, you might have seen in news, NSA is coming in or some intelligence agencies are coming into a city, Coimbatore, Chennai, Bangalore, Mysore, Delhi, and taking people under custody without saying any reason. That might be a part of promoting cyber terrorism, right? You get a mail saying that, hey, you want to become a jihad and join this group, immediately you need to delete and report it. Even if you have the message in email, after reading that might be an offense, right? If at all it's against the sovereignty of the country, because this is going to affect the whole of the nation. Fine. 66F is threatening the unity, integrity, security, and sovereignty of the India. See, you have an email, you have a message, you are a part of a WhatsApp group, you are a part of a Telegram group. You see that at the bottom, punishment is life imprisonment or even greater. Right? First few months will be non-bailable. Right? Keep in mind. 67 is cyber pornography, right? Sexually abusive. It can be audio, it can be a video, it can be a photo, even it can be a text message, right? 67, country to country difference, right? There is a punishment for cyber pornography. But 67B is the thing which I mentioned. Creating, collecting, browsing, downloading, or having a possession of a, again, audio, a video, a photo, even a text message, a chat involving child pornography. A child, it can be a boy or a girl below 18, involved in that conversation, which is a digital evidence that is available in your device, you are held liable for that, right? Keep in mind, cyber terrorism and child pornography are so severe, not only in India, it's across the globe, right? Okay. Who can prosecute, right? File a case against this. Being a citizen, you can just go and file or apply for that. But you see, government agencies, if you are hearing this for the first time, NTRO, certain military cert, intelligence agencies, CID, CBI, forensic lab, and finally, police and cyber cells, right? All these agencies, government agencies can enact this IT Act with their powers. Fine. And what are the broad categories? Cybercrimes are categories. Cybercrimes against government. Someone is doing an attack against government website. Cybercrimes against property, a property of you, a program, a source code, your company or your website or something. Cybercrimes against a person, fake website, fake accounts, hacking into someone else's account, getting their mails, right? Against government, against a property, a digital property, and against a person or an individual. Fine. So this is a nutshell of the existing cyber laws, IT Act 2000, IT Act 2008. Now we are in 2025. A couple of years ago, there was something called BSA, Bharatiya Sakshya Adhiniyam. I hope I'm spelling it right. That was introduced in the courts of law in India. It was enacted last year, July 1st, in all the courts of India, replacing Indian Evidence Act. See, India had an act for evidences. It can be a older paper evidence. It can be audio. It can be a video. There's an evidence. That's now what we call as a digital evidence, right? It was 151 years old. 1872 amendment. We follow traditional UK-based laws and all. But it was changed, formulated what India needs, what has to be there for the soundity of the nation, right? Everything was changed and it was named as BSA, Bharatiya Sakshya Adhinam. Three things as there. So today's the second part, maybe the first part is done. Second part we are going to discuss. Hey, fine. Sir, you mentioned all about cyber laws in India. I got a clear idea. I want to produce an electronic evidence in the court of law. How to produce? And keep in mind, I throw the disclaimer again. We are just sharing our experiences based upon the evidences which we handle. The legal term, what you go in the law, the prosecution, the cross-examination will be different. Fine. There was something called 65B, right, of Indian Evidence Act. The previous laws was renamed as 63(4)C. The numbers may differ, but keep in mind, you want to produce an electronic evidence in any court of law in India, you need to have these certificates. Right? You imagine it like a license, you get it. You imagine it like a degree certificate. The certificate says you went to the college, 4 years you studied, you got the degree. Same way, this certificate will say, hey, this is a WhatsApp evidence, or this is the photo taken from the mobile, or this is the email available in the company account, and attached with the proper certificate, right? We bounce back, we bounce back. So everyone knows the domains we are crossing. So we'll move on to the practice part. We'll let you know how we practice, right? So the agenda, the talk for today from Team Kriyavan, because we don't want to say an individual, we have a pool of cyber people, lawyers, those who are from government, those who support us from NGOs and many, it's a group, right? Whatever speakers we had earlier are all our supporters, right? The common cause is cybersecurity is our shared responsibility. So only we named this day 6 topic as from Team Kriyavan. What Team Kriyavan had done in the past 3 years, we have worked out with 100 plus cyber crimes. We don't call it as a case, we call it as a service request. We don't substitute police, we don't do any policing work. We work based upon evidence. You give an audio, you give a video, you give an email, we make it in a forensically sound manner and give you the report. 100 or 100 plus service request addressed and 1,000 hours of investigation, right? So that is the agenda for the next 20 minutes. Crime scene to courtroom, the real world insights on digital evidence that stand. In layman terms, you want to show or prove a digital evidence in the court of law. Just like that, you just copy it in a pen drive, put it in a CD, or send it over the mail to them. It won't be accepted. And as we follow the traditional IT Act 2000, 2008, and recent ones, something has to be an evidence. You know, right? In traditional crimes, someone kills someone, the knife will be the primary evidence with the blood stain or fingerprint and everything. Same way in digital evidence, it can be audio, it can be a photo, it can be a video, it can be a document, it can be an email, it can be a cloud data you store on the online drives, right? So that is going to be the digital evidence. So initially, it has to be proven as an evidence in the court. Then it has to be accepted as an electronic evidence in the court. Then we have the category, primary evidence, secondary evidence, copy of the evidence. If everything is accepted, then they will say, hey, fine, this photo was taken in the mobile, it was deleted. We are accepting in the court of law. You cannot randomly go and just prove something as you're right. I remember like some of our peers, first time when they do investigation, a photo is deleted from the mobile. What we do, we take the mobile, we just use a recovery software, put it, mobile or a laptop or a hard disk, and you recover the photo, say, hey, this was the photo deleted, it was recovered. Normal data recovery mechanism. But in court proceedings, that will be different. We have an evidence mobile. Initially, the mobile has to be taken into custody. It has to be submitted to a forensic lab or private investigating agencies, right? Accepting it as an evidence in court of law from a forensic lab or a private investigating agency, it's up to the jury. The court will decide, right? But when you get an evidence, let us assume like you have a mobile. Let's assume you have this mobile device, which is going to be produced as an electronic evidence in the court of law. Fine. So we get the mobile. We say like, okay, it's 128 GB internal memory. We make a copy of the evidence in forensic or digital forensic. You should not touch the original evidence. You see like that, like traditional crimes, the knife will be produced in the court of law. You should not touch the original evidence. You can keep multiple copies of the evidence. We call it as forensic imaging, copy of the original evidence, right? So we take multiple copies of forensic evidences. So that is all about 63(4)(c) of BSA, proving or showing or providing something in the code of law as an electronic evidence. Fine. These three laws, as I said, BNS, BNSS and BSA. You see, this was enacted in 2023. The same thing, the older IT Act 2008 comes in some different sections with some new updates, right? So as I said, there was a computer, there was a mobile, now we are using cloud, now we are storing something online, right? Everything has been upgraded. Okay. So as a matter of fact of time, right? So we are on the second 20 minutes, right? So I'll let you know if you want to provide, let's say we'll take a simple example. I'll give you an example in which there was an employee working in a company. He just stolen the company data and he have put it in a pen drive and he have just given it to the competitor. This was one of their clients. We don't really openly say the names and things. But this is the abstract, right? An employee working in a company have copied the company contract document and sent it outside. So the company have identified it after 1 month. This was so hardcore. But sometimes companies used to identify after 6 months, after 1 year, or even greater, right? So they called us and they said, sir, I know this employee has stolen the contract document. He have given it to the competitive company. They have a solid proof that the other company is also informed them due to some ethical issues, right? They have informed them saying that, hey, we have got a document from so and so, right? So if you want to produce it in the court of law, what should be there is this one. Section 63(4), the subdivision C, will have two parts, part A and part B. Part A is to be filled in by the party, the owner of the device. For example, you see I, son, daughter, spouse of the residing at the place. What is the electronic evidence? Computer storage, DVR, CD, DVD, server, cloud. What is the make and model? Hey, this is an Oppo mobile. This is using Android version 14. The color is something on red color. The serial number of the mobile. If at all it's a mobile device, you need to know about IMEI, IMSIs and on. And finally, you need to have photographs of that, right? You have a photograph of that and store it. So when you get an electronic evidence, you need to initially make a photograph, check all these basic things and preserve it. Then you make multiple copies of the evidence using any forensic software. We are not going to talk on the technical part. There are softwares available, tools that can copy a mobile evidence, copy a hard disk evidence, copy a pen drive evidence, copy a cloud evidence, copy evidences from Apple devices and on. Fine. See at the bottom, see I am the owner of the device. I am maintaining the device. For example, you are the sysadmin of the company. You are giving the evidence. You are the manager of the company. You are giving the evidence. You are the service provider. The company have outsourced the IT support to your team, right? So that is on this 63(4)(c). Part A will be given by the party who is giving the evidence to the court. And the continuation of that. So the evidences will have something called hashes. I hope some of our speakers might have discussed of this. I'm sending you a message, meet me at 6. You are receiving the message, meet me at 9. The conclusion, the message is modified. Same way, this mobile has to be proven in the court of law. The mobile from the first bit till the last bit without any modification that has to be produced in the court of law. So we call it hashing. You take the mobile, copy in a forensically sound manner. Before and after you hash it, you verify the hashes are matching, right? So most of the things, there are quite a good number of cross-examination questions comes in court of law for this hashing. How you hashed, which hash you used, whether you follow the standard, right? Whether an empty file will have a zero hash. Many questions will come in the court of law when you go as an expert witness, right? But keep in mind, you give an electronic evidence, it can be a mobile, it can be a photo, it can be an email. Each and every evidences can be verified using a signature. Just like you sign, hashes are cryptographic signatures that can be verified. The most common is MD5, SHA-1, SHA-2. Fine. So this is the first certificate, 63(4)(c), Part A, given by the party, the owner of the evidence. The second certificate will be given by the Part B will be given by the expert. Expert can be from government forensic lab. There are some clauses, basic qualification to be an expert or a expert witness in the court of law. The expert will give the same thing. Hey, who, their identity, so and so, what was the device, make, model, and who owned, who maintained. The expert will give something called as chain of custody that was not mentioned here. There will be a document called chain of custody. Will say, I got the mobile in this device. Hashes are there, evidences are there. I analyzed using this software. The software is a approved software to be proven in court of law. The software gave the report. The report is produced by so and so. This so and so person is a forensic person. He have already analyzed this many cases. He is an expert in the court of law, right? Everything has to be there in the document. But this one simple document which we see here is the 63-4C of PSA. If you want, I'll just show you a sample document. Just see this PDF. See, this is one of the sample format. Again, it's a public to use format, so I'm showing it here. SR is the service request number. When we got the service request, where it is stored. You see, there will be something called as a property record number. What was the evidence? Who was the investigator? What was the service request ID? We don't call it as a case. We call it as a service request. What was the service request ID? And the same format you see here, you saw in the previous template document. The same format. Who gave it? What was the thing? See the metadata. Metadata in the sense, what was the make, what was the model, what was the kernel, what was the serial number, whether the mobile is turned on or off, what was the charge of the mobile, what was the display screen of the mobile. Because the court proceedings, right, common in Indian courts. When you file a case, the court proceedings will come after 6 months, 8 months, 1 year, or even greater. Right, the cyber crimes that have been stacked in the court of law, fine, in India. So if the court proceedings might come after 1 year, you be an expert giving a forensic report. So at that time, when you have been called, you'll go back and read the old document. Hey, that was a Realme mobile, the red color mobile, this make and model. The mobile was this. That was to prove that the photo was taken in the mobile, that was deleted, and it was recovered using this software. Everything will be available in the forensic report. Fine. And this is the part B to be given by the expert. Who is the expert? What is the identity? What was the device? What was the make and model? Fine.